Good morning, everyone, and welcome to our webinar on the Consumer Protection Act and Sale of Goods Act on this very damp and blustery Wednesday morning. My name's Terry O'Keefe. I'm going to be the moderator today, and we're really fortunate to have as our guests Bob Pierce from the UCDA and Farah Mohammed, staff here at OMVIC, and I'm going to give them a second to introduce themselves and tell you a little bit about themselves.
Well, thanks, Terry, and I guess our third time together. I'm the Director of Member Services for the Used Car Dealers Association. Sort of a very long history in the car business. Was part of the New Car Dealers Association as CEO and was previous registrar before OMVIC was formed. So a lot of interesting stuff's happened since then.
Good morning, everyone. My name is Farah Mohammed. I am currently a communications officer with OMVIC, previously an inspector, business standards officer, and advertising specialist, and prior to that, a complaint handler. So I've had my experience here with OMVIC, and I'm excited to speak to everyone about the CPA and Sales of Goods Act today.
So the Consumer Protection Act is something that you should know about it. It applies to most businesses. This is not a piece of legislation that is specific to car dealers or vehicle sales. It applies to almost all transactions in the province of Ontario. And there's something else though that you should know about it is that these regulations and the protections that are provided by them only apply to consumers and to someone who meets the definition of a consumer. And Bob's going to talk a little bit more about that in just 1 second. And the other thing I'd like to mention to you is that the protections, though, that the Consumer Protection Act does generate can't be nullified in a contract. No clause in a contract can remove the protections or rights that a consumer might derive from this legislation.
And thanks, Terry. And I think that it's also important to understand that having teaching the course, certification course for OMVIC, and visiting the dealers in the last 7 years, it's probably the least understood piece of legislation. You know, the C is for consumer protection. It's not dealer protection. And when we go through today, and I hope they find it rather interesting that if there's a court, for example, is going to make a decision, they're going to err on the side of the consumer. And I find a lot of people can't understand that. It's not dealer protection. And the consumer is not as sophisticated as what we're seen to be in the industry, and they're going to be given the benefit of the doubt. So it's a really not really well understood piece of legislation.
And hopefully what we're doing today is going to shed some light on all of that. So Bob, not all customers are consumers, but all consumers are customers.
Yeah, it's another part of the confusion I was talking about. And I, again, in the class, I teach this and try and make people understand it, that, you know, somebody coming in the industry to buy 3 cabs and somebody coming in to buy their personal use vehicle, they're both customers of the dealership and they're both valued, but only one of them is protected by the legislation, and that's the person buying goods for personal use. And that's the same for most retail stores. If you're going in to buy a printer for your printing company, you can't use this legislation to help you. So in our business, if it's a business purchase, you're on your own. This is for consumers.
Now, in our past webinars that we've performed for everyone, it's been surrounded around the Motor Vehicle Dealers Act, but the Consumer Protections Act is very similar in the sense that it provides examples, definitions, and representations, and it sets boundaries for consumers and for businesses when dealing with consumers.
And I think the one thing that if you take nothing away from the Consumer Protection Act webinar we're doing today, it is this: thou shalt not commit an unfair business practice. And there's 2 kinds. And Bob, you want to do the first one?
The unfair business practices or the unconscionable? Which ones? Again, you know, we're going to get into some sort of pretty nasty stuff right now. And what I want to the industry is that this type of stuff doesn't happen very often. But when it does, it gets very public and it doesn't make us look good.
I think that's a really good point, Bob. When the CPA gets breached, it often attracts a lot of attention, and we're going to look at some examples of that.
And if you do recall the infamous W5 video clip pertaining to secret shops within the province of Ontario, here's an example of a dealer and a salesperson who have been actually disciplined through our disciplinary process for unfair business practices and representing an OMVIC fee as a government fee, and adding hundreds of dollars onto what at the time was a $5 OMVIC fee. The salesperson and the dealer were both named in the notice that they had received, and unfortunately the salesperson has since left the industry, but the dealer was very cooperative in providing any information with regards to this and with cooperating with OMVIC and our disciplinary process.
And what this is an example of is the first kind of an unfair business practice, which would be a false, misleading, or deceptive representation. And there's a number of different examples that are set out in the legislation. And this is not an exhaustive list. These are examples, and I don't know, Farah, if you'd like to go through them.
Yeah, so if the dealer or salesperson misrepresents the purpose of an additional charge, that's one. Saying that there's a specific price advantage if it's not true. Understating the distance that the vehicle has been driven or the amount of use it has had. That's a very important one. Or saying that the car is a particular model, style, quality, or grade that it's not. Another one is telling the customer or the consumer rather that the car can perform in a way that it cannot, or if it's still under the manufacturer's warranty, for example, just to name a few.
And there's another type of unfair business practices. It's the second kind, and it is, Bob?
The unconscionable one. And it, just as the word says, I think you had to go out of your way to breach this one, and it was very deliberate. And certainly they took advantage of a situation on a customer that simply couldn't protect her interests in this car deal. And you take a look at some of the terms on unconscionable, and the price grossly exceeds that for which goods or services are available like consumers, like the OMVIC fee. It's $5 now, $10. That fellow was representing it as $300. So you've got a whole host of things that sort of go to the extreme.
And the unconscionable, it really is, these are the term basically means doing something or making a representation that a normal person, if there is such a thing, can't do in good conscience, wouldn't do in good conscience.
Or innocently, and we take a look at our society, and we have a lot of people in this country, English is not their first language. And we simply can't take advantage of that when you start putting people into leases. And one example I have is where the salesman said, well, I speak that language and I was his interpreter. And I asked him to define some of the lease terms in that language, and he couldn't. So how much did the customer really understood? But they walked out of the door with a 4-year lease. They had no idea what they got into.
And to look at the examples that are here, so the consumer can't protect his or her own interest, perhaps because of a disability or an impairment. As Bob had already mentioned, the price grossly exceeds the price that should have been charged, basically. The dealer or salesperson put too much pressure on the customer.
This one is interesting because this one is the consumer is not likely to pay the debt in full. And when we go into this example, there's no way somebody making $1,600 a month could pay a $650 car payment on a car where the price grossly exceeded what the normal person would have paid for it anyway. So these people had to be trying to do this. This wasn't accidental.
And the last one here, the dealer or salesperson gave a misleading opinion and the consumer relied on it to his or her detriment. And the example that Bob is talking about is the picture that you see just on the left, which is taken from the front page of the Toronto Star.
Yeah, and again, you've got an individual that has a mental disability, but not serious enough that she can't function. She comes into a dealership to have her tires changed from her winter to summer and ends up spending $66,000 for a $40,000 car. And if you and I were going to be buying rust proofing for $1,500, she paid $4,500 for it because in her particular state, it sounded reasonable and she thought a warranty was good or something like that. And they took advantage of that lack of understanding. And it doesn't take much in the stores to do that.
And I think it's important to note that when these things do happen, as we talked about, sometimes they can generate media interest, which is certainly the case here, because they offend many people's just sense of right and wrong.
Oh, when I teach this to the class, and these are new people coming in, they're just shocked this type of behavior would happen in our industry today. And again, this happens so rarely, but when it does, it gets very public, and the consequences are dire.
In this particular instance, the dealership and two of the senior managers at the dealership were all charged and convicted, and proposals were issued to revoke their licenses.
Right.
And of course, it was a Mazda store at the time. The manufacturer also got involved.
Well, I think between the actions of OMVIC and the manufacturer, if we would have taken, when I was provincial registrar, just through the regulatory process to take the dealer's license away, probably would have taken me 3 to 4 years, depending on the appeals they would have made. OMVIC and the manufacturer shut this thing down in 4 days. And it went from an operating, successful dealership to boarded up, windows covered, people out of work, and it stayed that way for 6 months.
Well, that was that was not OMVIC that actually shut them down. That was the manufacturer that revoked their.
But it also illustrates
their
the kind of powers that OMVIC has under the new legislation when this situation, as rare as it is, needs to be shut down.
And as Bob mentioned just previously, the consequences can be dire. So I'm sure you all remember this press release that was issued with regards to Mr. Naheed Ramji, who received a 7-month jail sentence for an unconscionable representation. Basically, Mr. Ramji had an elderly consumer sign a contract for a lease of a term of up to 8 years for $43,000. The consumer was charged $24,000 more than she had expected, and this has become one of the first auto dealership employees. So this is not the dealership, it's the salesperson that was jailed under the consumer protection legislation for an unconscionable representation.
And because we're talking about false, misleading, deceptive representations, I thought it might be an opportunity to touch back just on the most recent dealer standard that everyone listening would have received. And it talked a little bit about the mystery shopping that OMVIC did in the spring. And one of the areas of concern that was raised, of the 20 dealerships that were visited, in each instance, the mystery shoppers asked about the warranties on the vehicles, because these were new vehicles, and also asked about the corrosion warranty. 6 salespersons told the mystery shoppers there was no corrosion warranty, and 4 then tried to sell a rust warranty, when in fact there was a corrosion warranty from the manufacturer. So is that a false, misleading, or deceptive practice, Bob?
Yeah, I think that's pretty safe to say. And again, you know, in the GTA where OMVIC is, the industry has to understand is you never know who's asking you these questions. And in the fellow that misrepresented the $300 OMVIC fee, he didn't know that the person had a camera on him, and he was going to be on the national news. So I refer to this one in the classes. This guy decided he'd be the poster child for stupid on this particular day in the industry and try and get away with this, and he didn't.
And again, you bring up the news because these things do generate interest. And here's just another example. So this is a recent scenario that unfolded. So the consumer is in the F&I office and is asked if they would like to purchase tinting winter mats, and the consumer declined. The finance person allegedly persisted and said, what about the Platinum Shield protection package? And again, the consumer declined. The consumer then claims that the finance person said, well, you can turn these down, but you'll have to sign a waiver stating you declined the rust proofing, and therefore the manufacturer will no longer be liable for any electrical damage that the car incurs. And if you get rust proofing done by a third party, it'll also void the warranty.
And on that point, too, just before we go on, you know, the CPA has set out that oral evidence can be considered by the court if the court believes that it's reasonable that this type of conversation could take place, unlike in the Motor Vehicle Dealers Act, where everything has to be in writing, clear, comprehensive, and prominent. What you say can be just as important as what you write down.
That's an excellent, excellent point. So the question is, you know, does this type of representation violate the CPA? And I know we got ahead on the slide here, but yes, it does. Not only are there false allegations and misleading representations, but it also could be on the unconscionable side, because the manager could be putting undue pressure on the consumer by saying, oh, well, the warranty is going to be void on your car. And as we talked about, this isn't just a scenario that, you know, we're discussing here today. This whole scenario, this whole story comes from a story in the Globe and Mail. These types of activities attract not just attention from the regulator, but from the media.
So what happens if the CPA is violated, if the Consumer Protections Act is violated? And we discussed the Mazda of Orangeville scenario as well as Mr. Ramji. And what is very important is that we all know that individuals, so not just the dealership, not just the entity, but individuals are convicted, who are convicted of an offense under the Consumer Protections Act can receive a maximum of 2 years less a day in jail and or a fine of up to $50,000. And a corporation, so on the dealership side, a corporation can be convicted and fined under the maximum of $250,000. So the fines are substantial.
Yeah, and thanks, Sarah. And the other thing I think the industry should understand very clearly is what you say and what you write down, you can be held responsible for about 12 months, and that's the rescission period for the deal. Of course, if they come early, it could be the rescission of the entire deal. If they come in the 11th month, they probably won't get everything they're asking for, but the industry is responsible to that consumer and the CPA for a year. You know, and that's a huge liability down the line if you're caught talking and writing and doing things like this.
That's right. There's a 1 year rescission period for consumers if there has been an unfair business practice.
Mm-hmm. And that's not to be confused with the 90-day rescission policy under the Motor Vehicle Dealers Act. So it's very important that our audience understands that there is a 12-month, 1 year, like you said, Terry, rescission policy under the CPA.
And that 1 year period is when a consumer can cancel the contract, but that doesn't mean that if they discover the unfair practice beyond that they're not entitled to seek some kind of compensation. They may not be able to rescind the contract, but they could still seek compensation. And there's an example here, and it's Shelley, as you can see, bought a 2006 Honda. It was advertised as having ABS. That was important to Shelley because she doesn't like driving in the snow. 13 months later, she's driving in the snow. She steps on the brakes as she approaches the light, and her little Honda goes around and around and around, and it frightens her. And off she goes to the Honda dealer to say, there's something wrong with my car because the anti-lock brakes don't seem to be working. I spun out this morning. And the dealer says, that model didn't come with ABS. Well, that was really important to Shelley. She asked, the car was advertised as having it, so there was a misrepresentation. But she's beyond the 1 year period. She can't rescind now, but that doesn't mean that she can't seek compensation. She could go to small claims court and seek compensation from the dealer that represented the vehicle as having ABS when in fact it didn't.
And again, you're on with that, and I talked earlier about this is the C stands for consumer. Under Section 19, or 18, I guess it is, the oral evidence rule under the Act, and the CPA is rather unique like that. In most court cases, you have the best evidence rules and stuff have to be in writing. But under the CPA, if a judge believes that this conversation could have taken place, and judges buy cars too, then the judge will make the determination that it was said. And we talk about things like canceling deals and going and keeping deposits. And the salesman said, yeah, go ahead, give me a deposit and go home and think about it, bring your partner down, and if she doesn't like it or he doesn't like it, we'll give you your money back. Well, nothing's in writing. In court, a judge is going to say, that's a pretty reasonable thing a salesperson might say, in which case they'll err on the side of the consumer. So oral evidence under the CPAs is important,
With regards to material facts has been a consistent theme in all of our webinars. It's consistent within the Motor Vehicle Dealers Act and in the Consumer Protections Act. And a material fact is, and I'm sure our audience is well aware of what a material fact is, but just to remind you, a material fact is something that can alter a consumer's decision in purchasing, in this case, a motor vehicle or not purchasing a motor vehicle. Some piece of information that would be important to them. And the Consumer Protections Act assumes that dealers and salespeople have more resources and knowledge and experience than a consumer does in determining what the facts are about the vehicles.
Well, and fair on that point, I think the internet's been the great equalizer over the years. The CPA, I think, was written in the 40s. And now I think that although I think it still is a rule in place, the internet allows the consumer to become more aware of what you're telling them, and it's not true. Exactly. So I think the internet's been one of the great equalizers there. And I get often asked, we're not a perfect industry. And I talk to a lot of dealer principals. You try and manage, you try and educate, but we make honest mistakes, and the CPA takes that into consideration. However, it's a mistake. It may speak to the penalty you may or may not get, but at the end of the day, the consumer is going to be made whole. It's going to be made right for them. Honest mistake or not, you're still going to have to deal with a consumer problem you created because you didn't know. And I think this is a good thing about these webinars, and I'll talk about that later. There's a lot of opportunity to learn this stuff if you choose to.
Yeah, and Bob, that's a very, very good point. And in this example, the dealer bought a vehicle with thought it had 92,000 kilometers on it. They paid the fair price for a vehicle that had 92,000 kilometers on it. 6 months later, so we're beyond the 90 days that the MVDA would grant automatically for rescission for not disclosing the true distance a vehicle has traveled. But 6 months later, the consumer discovers the vehicle, in fact, does have a rollback odometer. Mm-hmm. Even though the dealer honestly believed the car only had 92,000 kilometers on it, paid fair market value for it, that consumer would still be entitled to rescission under the CPA.
Exactly. Remember that key 1 year period that they can bring that to the dealer's attention.
And another interesting term under the CPA is ambiguity. If your contract is you don't have a tough time saying that.
Ambiguous.
Ambiguous. And the Motor Vehicle Dealers Act has moved to plain language contracts. A lot of industries haven't, but if it is determined to be ambiguous, it's going to be then ruled in favor of the consumer. It's the industry's contract. If something's written on the contract that's not clear and is ambiguous, they're going to resolve the issue in favor of the consumer.
That's right. The ambiguity will be interpreted in favor of the customer, or the consumer.
The CPA also sort of expands a lot through, I guess, re-regulation into the 2/3 rule for repossession. And essentially that rule of thumb has been around for ages, I guess, under the old Repair and Storage Liens Act. And that is if you finance a customer and the loan is $9,000, if they repay more than $6,000 or 2/3 of the loan, up to that $6,000, you can repo the vehicle if you're not being paid. But once it triggers the 2/3 rule, then you have to go to court and get court's approval to repo the car. And the rule of thumb there is the consumer owns 2/3 of the vehicle, you only own 1/3. And it's not to say you won't get to be able to repossess the vehicle, you're just probably going to have to prove to the court what you've done. And they're not listening and they're not responding, and likely you'll get the repo. But you have to be very careful not to start removing vehicles off some customer's driveway, and you've triggered the 2/3 rule. You find yourself with pretty serious consequences for doing that.
And now we want to talk to you about the Sale of Goods Act. You're probably looking at this going, why is that written that way? And why?
I thought for a second that was you, Terry.
Yeah, there is a similarity. Yeah, I used to have that. I've got a bowler hat like that at home.
I've known you a long time. That's why,
So why does it look like that, Bob?
Well, I think the act was written before cars were invented, and it really was. I think it's about 1890s or something. Sale of Goods Act was passed, and it's important to understand it still has relevance today. And when we go through the Sale of Goods Act, it speaks to more general terms, and that's the implied warranty sections of the S&G.
And that's exactly what we're going to spend a couple minutes talking about, is many, not just car dealers, again, this applies to most consumer transactions. This is not specific to cars. This applies to most consumer transactions. They don't realize that there are implied warranties granted by this piece of legislation, regardless of what's written on the bill of sale. The bill of sale can say no warranty. The Sale of Goods Act says there's 3, and they are.
Well, Terry, just tell me, a lot of these bills that we saw in the old days said no warranties expressed or implied.
Yes.
It's like somebody in the dealership has some magical wand that says the laws don't apply in this case.
Yeah. But that's a really good point, Bob, because the law will always apply regardless of what the contract says. And so there's 3 basically implied warranties. and for cars, that the vehicle be of merchantable quality, that it be fit for purpose, and that the buyer receive quiet possession.
And I think in the merchantable quality section, part of the act, and let's take it in relation to as-is vehicles, which I've talked about in previous webinars, is I still don't understand why anybody is selling a vehicle that really qualifies as is to the retail public. Apart from all of the disclosures you have to make under the MVDA as to why it's as is, you're still bound to this rule. You sold this vehicle to a customer as a motor vehicle. So yes, it's going to cost a lot of money to put it back on the road, but even at that point, it must reasonably be able to be used as a car for a reasonable period of time. You can't write yourself out of that. You can't wave your magic wand and say as is, and somehow you're not responsible. And a good example was one we were talking about earlier, and that the car was $1,000 and was sold as is with a further representation that only needed a muffler. It was $3,700 to put the estimate to put this thing back on the road. It was never going to be fit. That's an unreasonable amount of money to put into a $1,000 car, and it was never going to be fit for reasonable transportation for a reasonable period of time. So the entire case was thrown out by the courts, and the customer got their money back.
And I think it's important to note that that a car as Bob said, it's got to be of merchantable quality, and that means providing reasonable transportation for a reasonable period of time. What is reasonable could ultimately be up to a court to decide.
Absolutely. Yeah.
But if it's a $20,000 or $30,000 or $40,000 car, you would expect that reasonable period of time it's not a week.
That's right.
It's not on the way home.
Yeah. And you can also expect that the court is going to err on the side of the consumer. It's not dealer protection legislation, it's consumer protection legislation.
And the second implied warranty?
Is fit for purpose. So the vehicles, when you're selling a vehicle, it should be fit for purpose. So here's an example of, if you're looking at this image, it looks like an image of a boat that's going to pull a car to me. But if a purchaser is buying a car and tells a salesperson that he or she will be using the vehicle to tow a 3,000-pound boat, that vehicle that the purchaser is going to be purchasing must be fit for the purpose that the consumer is going to use that vehicle for. It does not need to be written into the sales agreement because the Sales of Goods Act implies that this is a condition within the contract. So as a best practice, we advise all dealers and salespersons to include all of the customer's conditions in writing on the sales contract in a clear, comprehensible, and prominent manner.
And quiet possession being the third of the three. And again, this really illustrates how old the legislation is, because I'm trying to figure out how I'd put this phrase into a sentence. And of course, they were doing it back in the 1800s. But it simply means you can't, and how relevant it is today, is you can't sell a car with a lien on it, and you can't sell a stolen vehicle. In those days, they were probably talking about ox carts and whatever back in those days, but now it's still relevant today because it talks about lien-free vehicles by dealers and the stolen vehicles that you have to be careful not to sell them because you're ultimately responsible for them.
Absolutely. Quiet possession basically means no one is going to come and try and take it away from the purchaser.
Right. And there we get back into as-is sales again. But again, the whole sale of this type of vehicle cannot be sort of, the Sale of Goods Act doesn't apply. All of the provisions in the CPA apply to the sale of a vehicle that meets the definition. That's not a car that's just without a safety or need test. This is likely an end-of-life vehicle. So, but if you're selling it as a motor vehicle, you still got the responsibility of the SGA.
And that's why it's recommended that dealers have consumers initial the required as-is disclosure statement if they're selling a vehicle under as-is terms. And I'm sure that we're all very aware of what the as-is statement is, prominently disclosed in bolded font on the contracts. And a buyer who reads and initials this statement may find it very difficult later on to argue that the implied conditions and warranties of the Sales of Goods Act should apply to this purchase. So it's very important that their signature is there.
But as Bob pointed out, in the one court case where this has been tried, the consumer actually was successful.
Yeah, it was. And you can't write yourself out of the Sale of Goods Act, period.
So, quick quiz.
Okay.
We're almost at the end, folks. So we just got a quick quiz for you here to see how you've done on the Consumer Protection Act.
Okay, so the two types of unfair practices are, so let's choose two from the four listed here. One, unconscionable representations. Two, ambiguous representations. Three,
Disingenuous.
It's
not three.
And four, false, misleading, or deceptive representations.
Bob, you get to answer this one.
True or false protection under the CPA?
You have to answer the first one.
I have to answer the first one. Oh, okay. Well, that would be 1 and from where I'm looking for.
That's it, 1 and 4.
1 and 4. Under the second question, true or false, protection under the CPA is granted or would apply to a carpenter buying a van for a small business. And of course, what I said in the beginning, absolutely not. They're not a consumer as defined by the CPA.
Exactly. Businesses are considered a customer, as we refer back to that slide, consumer versus customer. All right, and number 3, true or false, the Consumer Protections Act applies to sales, but not leases and not services such as repairs, Bob.
False.
False. It absolutely applies to both repairs and leases. In fact, the regulations covering motor vehicle repairs are found in the Consumer Protection Act.
The fourth one I find interesting. Consumer can waive their rights under the CPA, but this must be in writing. And first off, why would they? So to me, it's rather an interesting question as to why it's there. Why would somebody say, yeah, okay, that's fine. I want the protection of that law. And of course, the answer is, Terry?
Well, it's false, but it does happen. A business, for example, that's going door to door.
Well,
doing driveway paving,
right.
The CPA applies, and they might have something there that says this vehicle can't be canceled.
Right.
But of course, door-to-door sales under the CPA have a 10-day cooling off period that allows a consumer to cancel.
Which doesn't allow in our business whatsoever anyway.
Exactly. It doesn't apply to motor vehicle sales, right. the cooling off period.
And number 5, true or false, in matters related to the Consumer Protection Act, courts will only consider evidence that's written into the contract.
Oh, because oral evidence can be taken into consideration. We've talked about that twice. And the last question, if a dealer acted in good faith unknowingly breached the CPA, the consumer no longer is protected by the act, and again, fair.
That one is false.
Yeah.
The consumer is protected still.
The dealer may not find themselves being prosecuted, but that doesn't mean the consumer is not entitled to the protections, perhaps rescission, that's granted by the act.
Now that we've discussed the Consumer Protections Act, the CPA, we've done our advertising webinars, we've done our disclosure webinars, we're here to help. Our webinars are available on our website. So we do encourage dealers, salespeople, industry representatives to frequently visit our website, review our publications on a regular basis, review our webinars, and review the information pertaining to the Consumer Protections Act that is available under the MVDA Requirements tab. All the information is available on our website.
And within about a week, I guess, the UCDA's website under the OMVIC tab will have the 3 most important components, in my opinion, of the certification course. So that serves a couple of purposes. Let's say you've got a salesperson that's on the floor, he's in training, he's not selling, he's not registered yet, and he's going to take the course and then go write the test at Service Ontario. 70% of that book now can be listened to instead of trying to wade through legalese that you're not used to. But we do this in plain language, so it's a little easier to understand if you're getting ready to go to the Service Ontario to write your test. So it's 2 great resources, and I'm really pleased to have participated in it. It's been great.
And we're really pleased that you're able to participate too, Bob, and to have the UCDA participate in these webinars, because it brings an important voice to this educational opportunity, and the fact that not only are the recordings of the webinars, past and this one, will be shortly available on our site, they're available on your site too.
That's right, and I think what's important about the webinars is that the lack of knowledge in the industry is the reason I sincerely believe we make mistakes. And I think the more times we can come to the internet and read and have something like this, the fewer mistakes are going to be made. I don't believe anybody is out there deliberately, on the rare occasion they are, trying to beat up the consumer for every dime. Most of it, in my experience in visiting the dealers, is they simply didn't understand that provision of the act or this act entirely, in which the CPA is one of them. It's difficult to understand.
Of course, and we're not just saying to chime in on our webinars.
Yeah.
You can always give both UCDA and OMVIC a call to get that clarification.
Yeah.
Our representatives are well equipped to answer any of the questions that you may have with regards to the Sales of Goods Act, Consumer Protections Act, and the Motor Vehicle Dealers Act. So we do encourage everyone to utilize our complaints and inquiries team and contact the 1-800 number that is displayed currently.
And we've gotten a couple of questions in while we've been doing the webinar, and we just want to try and address them. If there are other questions that come in, our staff will get back to you. But these were one of them, a common one. And the question is, what about manufacturers' defects that are hidden from the dealers?
Well, that again is covered under different legislation than this.
And unfortunately, the protections of the CPA wouldn't apply because the dealer is not a consumer.
That's right.
So unfortunately, that the protections of the CPA wouldn't apply to a dealer that's being affected by hidden defects or misrepresentation by the manufacturer.
But they do have CAMVAP, and that's another thing that's in a lot of what we do is the consumer's ability to have that dispute with the manufacturer.
Exactly, and for those of you who don't know, CAMVAP stands for the Canadian Motor Vehicle Arbitration Plan.
Yeah.
And there's another question here, and this is an example. So you may get different answers to this question from different people here, but the dealer is asking, if I sell a car with 200,000 kilometers on it and the engine or transmission goes 2 months later, how does this legislation apply to a situation like that?
Well, I'd say that the major component section of the Motor Vehicle Dealers Act might come into play given the circumstances. So if a dealer is selling a motor vehicle, they need to be aware if there are any faults or any repairs that need to be done to any of those major components, the consumer should be aware, and that should be written on the contract.
I think in sort of plain language and in common sense, if you spent your last $5,000 on a car and it blew the engine 2 months later, I don't think you'd just say, well, I guess that's as long as the car should last. And I think the dealer would have some responsibility 1, 2, 3 months out, certainly not a year or 2 years later, but you know, any reasonable person, if you went to any reasonable other industry that's regulated under CPA, would expect some kind of compensation if you bought a $1,000 TV and 3 months later it blew up and stopped working. Very few of us would say, well, I guess that's how long that television should have lasted. So I think the easy answer is yes. I think the dealer would have some kind of obligation to meet the consumer halfway or do something in that span of period of time.
And certainly if the consumer came to OMVIC, our complaints and inquiries team would contact the dealer to see if there was some common ground that could be worked out. If the answer was no and the consumer wanted to pursue it further, they would have to, you know, go to court and ask a court to make that decision ultimately, if it went that far.
And if it went through the CPA, remember the C stands for consumer.
And the last question we've got here is, does OMVIC have distinct disclosures for bills of sale that 100% protect dealers?
No.
Again, it's the Consumer Protections Act, and OMVIC is facilitating the Motor Vehicle Dealers Act under the Ministry of Consumer and Government Services. The Ministry of Consumer Services is very important to be aware of, because we've got a whole government body that caters to consumer protection.
Right. And there is a section on the Act, though, it's on the back of it, and it talks about deposits. It's one of the most frequently issues in the industry the consumer complains about, and that's what happens in a deposit dispute. And it was written specifically for the protection of the dealer, and it's one of the ones I have to explain the most when I'm out there, because very few of us read the back of the bill of sale, and very few consumers read the back of the bill of sale. So it does have some stuff in it, but it is consumer legislation.
Yeah, and I think it's worth noting, I just don't want it to leave any confusion here, that there are distinct disclosures that are required under the Motor Vehicle Dealers Act, but they don't address what this particular individual is asking, that would 100% protect dealers. But making those disclosures absolutely does protect dealers.
Right.
Listen, I want to thank you, Bob, and the UCDA for joining us today.
Oh, you're very welcome. This is, again, something I enjoy doing.
Always a pleasure.
Farah, thank you very much. To Hassan and Taylor in the background here, working all the technological magic and getting the questions for us. Thank you. And especially to all the dealers and salespeople listening. Thank you very much.
Yep. Thanks a lot for coming on. Great.
Thank you for having us.
Stay dry.